This conference will now be recorded.
Well, good afternoon, everybody. This is Andrew Cole with East Orlando Chamber of Commerce. I hope everybody can hear me now. But just going from there, we have Probate 101 today with attorney Justin Meyer from Rosenthal and Meyer. I think I said that right. But as we always do, I do want to recognize our trustees before we start and just kind of get everything started here. So with the East Orlando Chamber, we have a number of trustees that are stakeholders within the chamber and our area. And those trustee members are Advent Health, Avalon Park Group, Avalon Insurance Services, Duke Energy, Fairwinds Credit Union, Great Florida Insurance, the Orlando Law Group, Orlando Health, and Suburban Land Reserve. And so without them, really, they are supporters of the chamber. They're stakeholders in our community. They hold a lot of great membership perks with us and mean a lot to us with giving us some guiding directions and things for the chamber. So we do appreciate all that they do, and I want to make sure that we give them due recognition. But really, I want to just go ahead and hand this over to Justin, who can just talk about who he is and what he does and all of that fun stuff. And we will take questions and answers in the chat box, and we'll answer those at the end of the, we'll have some time for Q&A. So just jot in your questions. We'll hit them as we go down. So if there's something that's right there and that you need answered, Justin can do that at the very end. So I'm going to give it over to Justin. Tell us all about Probate 101 and what we need to know. And I'm going to shut me down so you can have the floor. Take care.
All right. Thank you, Andrew. Good morning or good afternoon now. My name is Justin Meyer. I am an attorney with Rosenthal Meyer, and this is Probate 101. I want to thank everybody for joining us. Didn't work. There we go. A little bit about me. I work on corporate law and business law. I also do estate planning and probate. I work with small business owners. I work with families, and I work to cover the whole business, the whole person. I handle everything that they need. I'm admitted as an attorney in Florida. I'm also admitted in New York and New Jersey and several federal courts. And you can go to our website and learn more about me. Or come to chamber events because I like to come to a lot of them. I'm an ambassador with the chamber and I'm happy to be part of the chamber. I've been a member for about 2.5, 3 years now, and I found it to be a very rewarding experience. Before I go any farther, I have to do this. My malpractice carrier insists upon it. This is a general advice presentation. I'm not giving specific legal advice. I can't answer in the chat box questions that start with, my mother passed away 3 months ago. She has 4 creditors. What do we do? I'm really limited and I can give general information, but I can't answer specific questions here. But I'll make sure you have my contact information. You can reach out to me later as well if you need to. So what are we going to talk about? We're going to talk about what is probate. We're going to talk about planning ahead and avoiding it, whether you should. We'll talk about homestead and some other real estate issues. I know we have at least 1 or 2 real estate people here. I want to spend a little bit of time on how probate affects you because there are a lot of questions. My mom just died. What do I do with this house? And I kind of want to get into what you guys need to know about it as well. So let's get started. What's probate? Probate at its base is simply the court deciding who gets to inherit. And in Florida, this isn't true everywhere, but in Florida, probate is whether you have a will or not, you still have to go through probate. There's the probate court. Okay? You have a deceased person and you have their assets and the court decides who is inheriting and it supervises the process. This is important. In Florida, the process remains supervised by the court. In some other states, they are more hands-off. In Florida, the courts are hands-on. Okay, so what does this mean? It means probate obviously can only happen after death. Probate, it's a judicial process. There are courts involved. You may require an attorney. In the state of Florida, unless you are the sole beneficiary, you do have to bring on an attorney. And it means it can take time. A lot of probates can take a year or longer depending on the circumstances. Though I have been able to get them done sometimes in 3 to 6 months. Sometimes they can take 9 months to a year, or even longer. We'll get into that. We'll get into some of the differences. There are two kinds of probate: formal administration and summary administration. And a lot of people will look these up and they'll think that they know what they need, regardless of what the situation is. So I want to spend a little bit of time going over them. And the first one I want to go over is summary. It's quicker, it's easier, and a lot of people want to try and get into a summary proceeding if they can. But there are a couple of requirements and there are a couple of pitfalls with it that you should be aware of. So first, summary is only available for estates with a value under $75,000. This doesn't include the homestead property. Homestead is always going to be separate. Homestead is always going to be counted as a different asset or a different class of assets. But it's only available if the estate has $75,000 or less, or the deceased died more than 2 years ago. Okay? If you don't meet at least one of those prongs, you don't qualify for a summary proceeding. There we go. The other thing is it requires knowledge of the location and value of all the assets. They have to be disclosed on the petition. You can't say there may be a bank account at Wells Fargo. If you don't know where the bank accounts are, you can't do a summary administration. The reason for that is because there's nobody who takes control. You get a judge ordering the distribution of the assets, and that's it. If there are creditors, you need to know about them because you need to settle with the creditors as well. I'll talk a little bit about creditors if people are interested a little later on. But if there are creditors, you need to make sure you're addressing them here in the initial probate filing, and not because it won't be time to do it at the end. So summary administration seems like it's the easiest way to go. I will tell you, it can be harder, and it can take more effort from the get-go. So it's something to keep in mind. A lot of people rush to summary because they feel like they qualify, and then it turns out that it's harder. They don't know where all the assets are. They don't know the value of some of the assets, and that's a concern. On the other hand, you have formal probate. This can take a year. It is a process, but if you're going to find assets, if you know there's a bank account but you don't know how much money is in the bank account, if you think there was a life insurance policy but you're not sure, this is the process in which to handle it. Okay, the process takes longer because there's more that goes into it. You have the initial petition, you have a creditor period that is defined. You then have time to fight any creditor claims that come forward, and then finally you have the distribution. If you're going to sell property out of the estate, and we'll talk more about real estate later, but if the estate has property, it has a home, and we're not counting the homestead, it has a home, it has vacant land, it has a timeshare, and nobody wants it, and you're going to sell it before it gets to distribution, you need to do a formal probate. You cannot do a summary. Because again, the key thing here is that a formal probate names a personal representative to handle the estate. That's essential. It names a personal representative. There's somebody in charge of the estate. If you're going to be doing an ancillary probate in another state, somebody owns property in Florida, but they also owned a condo in New York or Arizona or wherever, and that state requires a personal representative, you need to do a formal probate. And I've had this come up. People have had questions about this. You have to do a formal probate if you're going to need a personal representative for any reason. This is usually a conversation that I have with clients and just kind of go over everything with them. All right. So again, personal representative needed if there'll be a probate in another state. Needed if there's a lawsuit pending or anticipated. Okay. If you think you're going to be filing a medical malpractice claim or a personal injury claim, somebody needs to be there to handle that, and that's where a personal representative comes in. So what's the role of the personal representative? They're responsible for gathering all of the assets, filing any tax returns, dealing with any creditors, making the distributions. You want this to be somebody you trust. You want this to be somebody who probably knows about your assets. A lot of people pick their children. If their children are in their 20s or 30s, at least. A lot of people pick close family members. Some people pick their attorneys. I will warn you, being the personal representative is a thankless job. We talked about before everything got started, we talked about the fact that Prince, Aretha Franklin, if you saw the blast today, died without a will, but so did Prince. Prince died without a will. And I'll get into briefly what happens if you die without a will in a moment, but because he died without a will, a personal representative was appointed, and they're still fighting over the value of his estate. It's still a fight going on. So it can be a thankless job. I've known trustees and personal representatives to get bogged down in litigation because two heirs aren't getting along and they're fighting. Make sure you've got somebody, if you think you're going to have a fight in your family, you want somebody who can be a peacemaker. That's just advice. Personal representative generally is named, oh, why is this not working now? There we go. In the last will and testament, okay? And a lot of people look at these and say, I've got a will, I'm good. I don't need to do anything and I don't need to worry about probate. No. A last will and testament is not valid until a judge has reviewed it and decided that and granted it and admitted it to probate. A last will and testament does not count for anything until a judge has ruled it to be valid. And then the terms of the will be followed. What does this mean? Whoops. It means a last will and testament does not avoid probate. And that's important. But what if you're probating an estate? And I'm going to jump off the slides for a second. What if you're probating an estate that doesn't have a will? Well, you're still going to have to do a lot of the same steps. In Florida, there's no difference between an estate with a will and an estate without one, except who gets everything. With a will, you can choose who gets what and how much of it. If you don't have a will, the state of Florida has created one for you. Okay? Your spouse has first priority to be the personal representative. If you have a spouse and children, and the children are all with your spouse, then your spouse gets everything. Otherwise, it's split between your spouse and your children. If they're children and no spouse, or their grandchildren, it starts going down the line. You go to your brothers and your sisters, and go to your cousins. If you don't have a will, you don't have a say. The state has created one for you, and you have to go by that. So how do you avoid all of this? How do you avoid probate? What's the secret? All right, let me jump in. Dorothy asked a question. Let me answer Dorothy's question before we jump into how to avoid probate. Do you mean it? All right, Dorothy's question. Do you mean if I have a notarized will is not valid regardless of what I request until a judge deems it valid? So first of all, for a will to be valid, it doesn't need to be notarized, though that helps. It needs to be signed by the testator, and it needs to have two witnesses. But then yes, it's not valid until a judge rules it to be valid. It should be notarized. That makes everything go a lot smoother when probate happens. But I can't take my will and take it to the bank. My wife, I pass away tomorrow. My wife takes my will, goes to the bank and says, his bank accounts are all mine. The bank's going to say, sorry, no. Get a court order. You're going to have to go to the court. You're going to have to file for probate using the will. A judge is going to look at the original copy, at the original will, and make sure that it's an actual will and it meets the standards set by the state of Florida. If you have a will that you executed in another state, As long as it was validly executed while you were in that state, it's a valid will. But you're going to have to, the judge is going to have to look at it and make sure that it's valid. 100%. That's the way it's going to go. Nobody's going to accept an unprobated will. And a quick question from Melissa: does Florida recognize a common law spouse? The answer to that is no. Florida does not recognize common law marriage anymore. I don't believe any state does. Actually, no, that's not true. I believe there are a few that do, but Florida is not, to the best of my knowledge, one of them. If you have a partner with whom you are not married, they do not inherit anything unless there is documentation that they should inherit. A will, a trust. I'm jumping ahead of myself on the trust, but a will or a trust or some, transfer on death accounts, and that's how they would inherit. So since I'm kind of crossing into that, let's talk about how you avoid probate. Probate has a bad rap in Florida. It can be difficult, it can be complicated, but it is not the end of the world. It is not the most expensive thing in the world. It is not the scariest. It is not quite the scary demon that people make it out to be. But a lot of people want to avoid probate. They want to not have to worry about a judge. They want to not have to worry about their partner. So how do you avoid it? There's a couple of different ways. The first is a trust. And a trust is a document that you create while you're alive, obviously. Lets you control what happens to your assets after death. You put your asset, now, in order for a trust to work, you have to actually put your assets into the trust. The worst thing you can have is a trust where you put nothing into it and all you have is a will saying, I leave everything to my trust, because then you're right back where you started from. Might as well have just done a will. You want to make sure you put your house, you put your car, you put all of your assets into the trust. That's a huge thing. But a trust avoids probate, lets assets go directly to who you want them to go to or not. I have 2 kids. They're 10 and 5. And I love my 2 kids. But I don't want to give them any money right now. I want to make sure they have money for education, for healthcare, for college. I don't want them getting my money right now if something happened to me. I don't want them getting my money when they turn 18 if something happened to me. I want the money to be there for them when they need it. And a trust lets me do that. A trust lets me say, if something happens to me tomorrow, my 10-year-old doesn't get any of my money until she turns 25 or 30. I had one client put in 60. That's how much he trusted his kid. When he's 60, he'll get the money. But it's one way to just keep control of the assets. If you want to make sure that a house, somebody can live in the house for the rest of their life, you put it into a trust. It's a way to protect assets and extend how much control you have over them. A will, you lose control pretty much immediately. A trust, you can keep control for 200-300 years if you really want to, if the assets are going to be around that long. Another way to avoid probate is transfer on death. You can name a beneficiary for most kinds of accounts. You can do a bank account, can have a transfer on death beneficiary, an IRA, an investment account. There's two names for it. It's going to be either TOD, transfer on death, or POD, pay on death, depending on where it is. And you can name beneficiaries. You can name contingent beneficiaries. Sometimes you can name multiple beneficiaries. And this is an easier way to avoid probate, but you lose control of the asset upon your death. So this works if my children were 25 and I just wanted them to have the money if something happened to me, I just name them as transfer on death beneficiaries and boom, it's done. No problem. They get the money and they go. If I want to keep control over the assets, though, this doesn't work. And that's an important distinction. So if I want to keep control over assets, this won't work for me, but this is a good way to get to avoid probate with assets that I just have on the side. Transfer on death can include a house if you do it right. life estates, and a life estate deed is a way to transfer your house to your children, so it goes to them upon your death. In Florida, we have what's called a ladybird or enhanced life estate deed, which lets you continue to control the house during your lifetime, including to sell it if you want, without your children's permission or whoever you leave the house to. Knowing that you have that ability is important. A lot of people kind of want to use them but don't know how. I'll tell you that they can be harder to sell a house with. That's why you want to make sure you have an attorney and a title company and a real estate agent who know what they're dealing with, but you can always back out of the ladybird deed if you have to. A life estate deed, which is not an enhanced life estate, and the difference is really in the verbiage on the deed. A life estate deed, there's no backing out of. So it is important to make sure that you have somebody who's drafting the deed who can go over that document with you, but you can do it. You can do a transfer on death for your house, if that's what you want to do, or not just for your house, but for any property at all. You can do a transfer on death. And that's something to consider. All right, before I move on to the next section, let's take the questions. Okay. So can assets be put into a trust if they're not paid off? Absolutely. So if I have a house, I'll take the house or I'll take the car, and I've got a mortgage on them, I can 100% put them into a trust. It does not trigger the due on sale clause. Putting it into a trust where I am the beneficiary. Now, here's the catch to that. What I can't do is put these into a trust for my children's benefit. I have to remain the primary beneficiary. As long as I remain the primary beneficiary of the trust, I can put it into a trust for my benefit. I can put it into a trust without triggering the due on sale clause. I or the trust will continue to pay the mortgage or the car payments or what have you, but you can absolutely transfer assets that still have a loan on them. Can I assume I can update my trust as I obtain more assets that I want to be protected by it? Anything not listed in the trust will be subject to probate. So, couple of things there. You don't need to update. The beauty of a trust, and actually the beauty of a will as well, is I don't have to update it. I have a house, I have a car, I have $5,000 worth of jewelry today, and that's all I have in the trust. That's all I have. I send it all over to the trust. I'll sign as part of my trust. So when we do estate planning, one of the things that we sign is an assignment of personal property. So anything that you buy today and going forward is assigned to the trust. It's a forward-looking assignment as well as a backward assignment. But I don't have to modify my trust. If I have one bank account in the trust and then I open 3 more bank accounts in the trust, as long as I have language in it that says all my bank accounts go to my child, my spouse, my absolute favorite Chamber of Commerce, which as we all know is the East Orlando Chamber of Commerce, unless I'm doing this for the Lake Nona Chamber, in which case it's still the East Orlando Chamber of Commerce, but I don't tell them that. Wait, this is being recorded. I can do all of, I don't need to update my trust because I've added assets. Only when I change how I want things to be distributed do I have to update the trust. So that's the beauty of a trust, is that it's very much a document that can encompass everything. A will is the same way. I leave my money I leave $50,000 to pick a charity. Orlando Health, the American Cancer Society, City of Orlando. If I have $50,000 in Bank of America today, and 5 years from now I move all my money to PNC, it doesn't matter. It's still $50,000. I don't have to update my will. I don't have to say where that money is coming from. All I have to do is say that I want my money to go to someone. And then one more question: can I put any stipulations on my TOD to be exclusive to my children, excluding significant others? So let me read half of that question. Can I put any stipulations on my TOD? No. TOD is TOD. It goes to them. But let me address the second half of that question, which is spouses. If you inherit money, that money belongs to you and is separate from your spouse. Until it's not. If I inherit $25,000 from my parents, my wife can't touch that money in a divorce. If we separate, the $25,000 can't be touched by her. However, there's a but to that, and that but is, how do I handle the money? If I start moving the money into joint accounts, it now can become a joint asset. So in answer to the question, if the TOD money goes to your children and they keep it as a separate account and don't use it for marital assets, you're fine. But if they use it and they bring it into the marriage, then it can become a marital asset. And it gets a little cloudy. And I don't handle family law, I don't handle divorce, so I know I refer a lot of that out, but that starts to get cloudy there. Keep in mind that with a trust, you can maintain separate accounts also. But you can also, if that's a concern, you can leave the money in trust for your children for their lifetimes, and then to go to your grandchildren for their benefit. One thing to consider is, if, as we get grim, an account that goes to a child. So child X inherits $10,000, $20,000, pick a number, let's call it $50,000, whether it be through a trust or a will or a transfer on death. If that person dies, that account is subject to their estate plan. So if you leave money that you intend to go to your children, but then to your grandchildren, you have to do it through a trust. You can't do it through a will or a transfer on death, because if they pass away, it may go to their spouse. Does that make sense? It's a lot that I just threw out there. There's a lot of words. Can't see anybody, which makes it always interesting. So, and this gets a little, this is where creativity comes in, and this is the fun part of it. And I'm happy to sit down and explain, talk to people about their situations as well. So let's talk about real estate. Let me note before we get started on this, and this will affect some people on the call, and it won't affect others. But this is one thing I want to bring to people's attention. The governor did extend the foreclosure and residential eviction moratorium for another month. This is going to be an issue that's going to affect people. And I want, as we talk about real estate, I want to make sure that the real estate people are aware, if they haven't heard, because it happened late yesterday. So you've got a house, not homestead. I want to make sure that is clear. Right now I'm talking about everything but the homestead property. Homestead property is a whole different kettle of fish. You start with, there's a piece of vacant land, there's a timeshare, there's a separate house, condo in Miami Beach. Unless there's a will and the will specifically allows it, a separate court order is going to be required to sell the real estate. And what do you need in order to sell real estate out of the estate? You need a personal representative also. Remember that. Again, you need a personal representative. Technically speaking, you need to get permission for the court to even list the property. Technically speaking. Do people do it the other way, where they list the property, they get an offer, and then they go to the court? Yeah. Will the judge sign the order? Yeah, probably. As long as it's fair, as long as it passes the stink test, the judge will probably sign the order. But you got to keep in mind that this is something that you need to be aware of. It will affect the timing. Now, a title company is going to pick up on this. A good title company, at least, is going to pick up on this. But it's something that will affect the timing every single time this comes up. Okay? Unless the will allows it, a separate court order is going to be required. And you want to, if you're a real estate agent and somebody comes to you and says, I've got a piece of property, my mom just died. Hey, is there a will? Hey, can I see the will? Mind if my lawyer friend takes a quick look at the will? Well, why do you want to know? I just want to see what I'm looking at time-wise. I just want to see what's out there. Because this could stall the process a couple of weeks, even a month. Some judges are taking longer with orders right now. I don't know how long that'll last. Courts get backed up. This may not, you know, you can't necessarily do an emergency filing because we decided to sell the house and didn't ask for permission. We're asking for permission now. So keep this in mind. Selling real estate, you may need a court order. You're going to want to look over that will and see if it says, I give permission to my personal representative to sell real estate. It's that simple. It's going to be, it can be buried in a lot of other texts, but you want something that says specifically that they can sell real estate. Okay, but that's everything but homestead. Homestead special. Homestead in Florida has its own special set of rules. All right. First of all, homestead property passes to heirs without creditors being able to touch it. Can also be devised outside of probate. So let's talk about what homestead is. Homestead, as you may know, is your primary residence in the state of Florida. You don't have to do anything to make it your homestead. It just has to be your primary residence within the state of Florida. Okay? In order to qualify for homestead, it has to be your primary residence. And I'm saying this again because I feel like what I'm saying is your primary residence in the state of Florida. What I mean is it has to be where you live most of the time. You can't have a primary residence in Florida and another one in New York. It has to be where you live most of the time, and it has to be within the state of Florida. If it is within an incorporated city, it's a quarter acre or less, or maybe a half acre. Now I'm drawing a blank for a second now. If it's outside of city limits, if it's an unincorporated territory, you've got a lot more space. Difference being that they're trying to protect farms outside. But any property over the size would no longer would be non-exempt homestead property, and that would get tricky, and that's a different ballgame. But you still need to go through a homestead property proceeding because you're dealing with some of it. Okay, because it passes outside, it can be passed outside of probate. You can file a separate homestead petition simply to devise that, give that property to the heirs. Okay. Next of kin, spouse, or to the children, or to the grandchildren, or to the mother and father, brothers and sisters. It goes to them. But I don't recommend doing it without doing a probate because of creditor issues. They can come up, and I've had it happen. Because it passes to heirs without the creditors being able to touch it, though, it's an asset that no matter how indebted the estate is, the primary beneficiaries, spouse and children or whatnot, are pretty much guaranteed to at least get something. But it is also important to make sure you're dealing with homestead in the appropriate way. And again, that's why the attorney helps. But if you're going to sell the homestead property, you generally can't sell it outside of the estate. Because it requires a separate court order, the estate, the personal representative, generally can't sell the homestead property, one, without voiding the homestead and opening it up to creditors, but two, because the title companies will generally say, well, this was homestead. Where's the homestead order? Okay. Having a good title company is really important here. Having a title company that knows this stuff is really important here, because you may need all of the heirs to sign off, and they're going to know that. They're going to know, wow, this is homestead, and two of the heirs are on board with everything that's happened in the probate, but there's these other two that we haven't heard from at all. They're entitled to to 1/4 of the probate of the property each. They're going to need to sign off. Having a title company that knows what they're doing here is essential. okay? Because if you don't, then you're running a real risk with with the sale having issues either in the very beginning or even later on, or even after the sale, quite frankly. So you want to make sure you're working with a title company and an attorney who knows that you got homestead property. If you're a real estate agent and you're looking at, and somebody calls you up and says, my mom just died and I've got a homestead property, I've got a piece of property, it's their homestead, 5 months. Tell them 5 months. I'm going to tell you why in a second. But homestead property takes longer to sell. Here's why. In order to sell the property, you're going to have to go through a couple of steps. First, you're going to have to file the initial petition for probate. You can file a homestead petition right then and there, and most judges will say no. Most judges will deny the petition, okay? After you get the letters of administration, you have to file what's called a notice to creditors. And you publish that, and that gives creditors 3 months to come forward and say, I'm entitled to assets from the estate. If any creditors come forward, they have a right to be heard on the homestead petition if they want to try and challenge it. They may fail, and this gets fact specific about whether it's a homestead or not. They may fail, but they have the right to do it. Because they can, what you end up with is now you're at 3 to 4 months already. If no creditors come forward, you file the homestead petition, you say no creditors came forward, and the judge usually will sign off on it. But if there's any creditors that came forward, the judge may ask for a hearing. That it can get, like I said, it can become more burdensome. If you're looking at a homestead property, you need to be planning for it to take months to sell, not weeks, and months to be ready to sell, not weeks. Are there ways to speed it up? Sometimes, but it's not easy. So this is where I manage expectations a lot with clients, and that's a big issue. Keep in mind also that with creditors, if any have filed claims, you may need, some courts will make you address those claims, not before they'll grant a homestead order, but they'll simultaneously. All right, so a question: if all the heirs do not agree, the sale would stall, and what happens then? Does the property stay in limbo and the estate pay all upkeep until everyone agrees the heirs die off? So here's the funny thing about homestead: is if the heirs don't agree, guess who gets the house? The heirs get the house. The estate stops paying for it. Once the homestead order is granted, excuse me, once the homestead order is granted, the estate is rid of the asset. The house goes to the heirs. So John Smith dies and is survived by Jack Smith, Don Smith, and Bob Smith. Jack and Don want to sell the house. Bob does not. They're stuck. Bob is going to be able to keep them from selling the house. Now, that's where you get into things like partition hearings and trying to force a sale. There are ways to do it that get expensive and get complicated again, but they're outside of probate. Even if the heirs all want to sell the house, the homestead order will give the property to the heirs. So Jack, Bob, and Don will be the owners of the property, and they will be the ones who have to sign all the paperwork. And if one doesn't want to, yeah, they can stall this for a while. It can get tricky. It can become complicated. I've seen siblings fight over what's going to happen with mom's house. It's always mom's. What's going to happen with mom's house, and there's been problems. Who's paying for the upkeep during that time? Who's paying HOA dues during that time? Who's paying power, light, water, gas if you have it, taxes? If you fight for too long, you'll lose the property, and that's the sad thing about this. Is an HOA most of the time will say, sorry for your loss. Pay us in a few months. If you can't pay us right now, pay us in a few months. but eventually they want to get paid, and eventually they'll start asking for money again. Mortgage company, most mortgage companies will say, we're sorry for your loss. We'll give you a couple of months to figure out what you want to do. Keep in mind, if there's a mortgage on a homestead property and you want to keep it, you're going to have to refinance that mortgage. So if you're selling it, you're going to pay off the mortgage, and you want to communicate that to the bank as best you can. I've seen banks go into try and put properties into foreclosure just because of bad communication between the bank and the personal representative or the proposed personal representative. I've seen banks try and put properties into foreclosure because they don't hear from anybody, because the heirs can't decide what they want to do. So they're just trying to protect their interest. They'll put the house into foreclosure just to see what their next step is, what they can do. But you want to keep in mind, communication is going to be key on something like this. But the mortgage is still going to be due. If you're keeping the house, the bank's going to make you refinance. The mortgage is still going to be due. The HOA is still going to be due. The property taxes are still going to be due. You can get a pass for a period of time, and how much that period of time is depends in part on the people involved. But it's not it's not indefinite. So yeah, if one sibling doesn't want to sell and wants to make life difficult, they can. And the end result is they could cause everybody to lose everything. But it'll probably end up in court before that happens. And quite frankly, in a situation like that, that's one sibling making lawyers a lot of money and not taking care of their family. So, can they force a sale? Could the ones wanting the sale sue the non-seller? Yeah, it's called partition. It happens outside. It would happen after the property was transferred. It would not be part of the probate process. It would not be part of the probate process, meaning it would not be with the same judge. That's an important point. Excuse me, is that you may end up in front of a different judge. It's possible that the probate judge would try and keep it, but you may end up in front of a different judge who doesn't know the family, who doesn't know the estate, who doesn't know all of the background. So negotiation is always the best strategy. Keeping some kind of open line is always the best strategy. If you know your family is going to fight over the house, excuse me, grab a drink real quick. If you know your family is going to fight over the house and you know you don't have any creditors, there are ways to break homestead. Okay? So the benefit, as I go back for a second, the benefit that it passes to heirs without the creditors being able to reach it. If I know there are no creditors in my estate, I have nothing to worry about there, but I also know that there's no way my kids are going to cooperate. I can do things to break homestead, and now the personal rep just has to sell it. Let the personal rep sell it. There are things that can be done if your situation in your family is not, if your family situation is such that the standard is not going to fit you, and everybody is different. Everybody has their own needs and a little bit of stuff that makes them interesting. And if you need something a little bit different, we can do that. There's a lot of ways to help people for whatever situation they need. And there's ways even around homestead issues. 100%, there's ways around homestead issues. Another way is to put it into a trust. Then you don't have to worry about a court order devising the homestead. You put it into the trust. And you say if one wants to buy it, if one wants to sell it and the other one doesn't, then the one who doesn't want to sell buys the other ones out. There are ways to be creative. There are ways to make it so that everything works the way you want it to. It's really a matter of what is your particular family situation. And what is your situation? What do you need? And a good attorney, us, and there are others in the area as well, will draft what you need. There's nobody who's going to say, here's your will. I hope you like it. I didn't listen to anything you said, but here it is. Now, what I will say before I get off my high horse is LegalZoom will not take into consideration what you need. Neither will Office Max. You will get a cookie cutter, one size fits all document from them, and it will not cover if you are worried about things like homestead property issues or anything else. I bring this up because people ask, well, why can't I just do with LegalZoom all the time? LegalZoom is so much cheaper than an attorney. Yeah, it is, but it's not good. It's just bad. And that's why, because at the end of the day, they don't take your needs into consideration. If the will or trust requests the property stay in the family for multiple generations, but 2 of the 4 kids want to sell it, does it sell or does it stay with the desire of the deceased? If it's a will, they sell it, or it becomes a thing. If it's a trust, you can keep it in the trust. If it's in the trust dictates. If it's in the will, the will can't keep it in the house in the family for multiple generations. So that's really important to know what you're dealing with, is a will or a trust. And that goes back to one of the things I'm going to say for the realtors. A lot of realtors I know will pull a deed just to see who owns the property, make sure that the people who are selling the property are the ones who own the property. You'll pull a deed. If it references a trust, ask to see a copy of the trust. Most do, I'm sure, but just make sure you have a copy. Yeah, just make sure you have a copy in your file. If it mentions somebody who's deceased, ask for a copy of the will. Get a copy for your file. Now, here's what I'll tell you: is a lot of them are available online, with certain levels of access to the clerks. If you can't find it and they're not, trust not so much. Trusts don't have to be filed. So, excuse me, trusts generally will not show up in court documents and court files, but a will should. And if the heirs are telling you, well, I don't really want to give you the will, call me. If I can find it, I'll get you a copy of it. If there's a probate file and you have a question about it, call me. I'll get it for you. I have access to the files in a bunch of counties. If I don't, I'll let you know, and we'll see if we can find a way to get it for you. You need to know what's in these documents. If they're not willing to show you the trust, eventually somebody's going to need to see it. The title company is going to ask for it. If they're not willing to show you the trust, ask them why. Somebody's going to want to look at it at some point. If there's a will, somebody's going to want to look at it at some point. Get it now. It'll save you some time. And again, if it's a will and you really and they won't give it to you, call me and I'll get it for you. I have no problem doing it. I know, like I said, most of the times I know where they're filed. If you give me the county, I can look them up. And if there's an order, I'll get the order. I can usually download the orders and I can download the will for you and I can get all that. It's not a problem to do it. So, but in a trust, so you want to make sure you're seeing what's in the trust. You want to make sure you're seeing what's in the will. Make sure everybody's got the permission to sell the property if they need to. Make sure there's no authorization needed. Nobody has to sign off on it, and that's always a big thing. Excuse me. But you want to also make sure if you want something done with your property long term, that you have it in a trust is the best way to do it. You can create, and as we start to get into, I guess, the estate planning side of this, you can get into land trusts that just hold property. You can get into just all sorts of different kinds of trusts. There's no substitute for sitting down with an attorney and talking about what you need and talking about how your assets, you want them to go and what you're looking for. Because so many different people have so many different needs, so many different things. So I said I'll make sure you have my contact information. Here it is. If, as I said to the realtors, if you need a trust or you need a, not a trust, if you need a will, let me know and I'll look for it. Look for an order if you need it. If you have questions you didn't want to ask here, email me. This is I don't know why I'm coughing so much today. This is a time where this is important. There's a lot of people who have questions right now about this topic. People are scared. People have been scared for a little while. I fielded more questions about probate and estate planning in the past 3 months than I did in a long while. Part of that's because my partner handles some of it, and part of that's because people are worried. A lot of people are worried now, and this is always a good thing to talk about. It's a good time to talk about it. But know what's going to happen if something happens. Know how to handle it. Prepare. The worst thing in the world is for you to have a will and nobody knows where it is. So make sure your personal representative that you name in the will, or your trustee name in the trust, knows where the trust of the will, know where all your documents are. Know how to find out what your assets are. Where do you bank? Do you have a list? You have a list of assets? Knows who your accountant is. Knows who your financial advisor is. All of that information you should have. One thing that we have, and if you email me, I'll send you a copy of it, is we actually made a document locator and set a series of information sheets. Happy to send that to anybody. Shoot me an email and ask for it, and I'll send it over to you. And it's a good way for you to list everything, where everything is, and who needs to be able to find things. So as I keep coughing, and I don't know why, and I feel bad. Any other questions? Or if not, I'm happy to answer questions privately. You can give me a call. You can shoot me an email. We can set up a time to talk. But I see Andrew's back on the screen holding a big hook. So,
Sort of. Well, what I've got going is I do have a question. I'll ask this one real quick because you keep talking about making sure you list who your either your folks are, the people that you want to manage it, and all of those. Do you need to have a backup for that? If, let's say, I have my brother, but what if he were to deceased? What if your person that you're willing it to, or your trust is going to, is in the same auto accident that you're in? Do you need to have a backup for that, or then do I have to put it in the trust of whoever his will has to now manage what put into my trust or put into my will? Does that make sense?
It makes sense, and the answer to that is it depends. So a couple of things. One is, if you should always have a backup for your power of attorney, for your trustee, for your personal representative. You should always have a backup. A lot of people name their spouse for at least some of these roles, and that's great. Except if my spouse, my wife and I, we go out to dinner a lot. Well, not now, but we used to go out to dinner a lot. And if we're driving down Narcoossee Road and we get hit in the car together, well, she's my healthcare proxy, she's my power of attorney, and she's my personal representative. So what happens? You want to make sure you have a backup. Maybe not somebody who lives in the same house as you, and you might want to do it strategically, but you want to make sure you have a backup for that. As for beneficiaries, yeah, you probably want to have a couple levels of backups. We say a lot of the time, so if I leave something to my children, as I said, I have 2 kids. If I leave something to my children, and if my children should die before me, then it goes to their children if they have any. If they don't, then it goes to their siblings. And if their sibling predeceased, if everybody dies, then to their siblings' children. And then, I mean, at some point you can only have so many backups. But I've seen people, I've done documents for people who have 4 or 5 levels of backups. And at the end, if I leave no beneficiary whatsoever, I leave it to this charity. If there's and sometimes they do that to avoid it going to somebody they don't want it to go to, who would be a next of kin who's 2 or 3 levels away. But sometimes they have a charity. If their children and their grandchildren or whatnot all predeceased them, they want to go there. So there's a lot of flexibility in that. One question that just got asked is, can I name my spouse and my kids jointly? Yes. I tend to like one personal representative, though some people, and I do this as well, will name all the children as joint personal representatives. Keep in mind, personal representative can get paid. So some people therefore make sure all the kids are doing it, so one kid doesn't get more money out of the estate than the others. But it's really a personal decision who your personal representative is going to be. It's about who you think can handle the job, and there are different reasons to discuss, one child over another, or both your children or your spouse, and it gets into a lot of personality driven issues as much as anything else.
Well, that sounds like a plan. I don't know if you have any other questions coming on your side, but if not, then we want to say thank you.
I think I hit everyone. Do I need one more? Do I need to designate my power of attorney, medical power of attorney, or other? Yeah, not in your will, not in your trust, but in power of attorney and a healthcare proxy, you really should name somebody. Those are important documents as well, and those are kind of outside the scope of this. But they are documents that you should have. So I think that's the last one. Like I said, my contact information is here. We handle, in addition to probate, we handle estate planning, we handle business law, we work with real estate agents, and today, or yesterday, because today's the 2nd, we started handling Medicaid issues as well. We just started that. We're very excited, and if I can help people, please, give me a call. If there are questions, I'm available.
Well, Justin, thank you very much. We appreciate all the information that you've given us today, and appreciate your involvement and engagement within the chamber. And everybody that has jumped on the call today, I hope you got some great information, and please feel free to reach out. And we've got plenty more coming up for the month of June. So we look forward to seeing you there. But Justin, thank you again. We appreciate it, and we hope to catch up with you real soon in the near future. Have a wonderful rest of your day, everybody. Take care.